All right, welcome back to Talk Testimonies. Today we're going deep on another Supreme Court case, one with some real implications for government transparency and business secrets. It's the Food Marketing Institute versus Argus Leader Media. Basically, this whole thing boils down to what confidential really means when it comes to commercial information the government holds, specifically under the Freedom of Information Act, better known as FOIA.
You got it. We're diving into the world of FOIA Exemption 4. That's the part of FOIA that allows the government to withhold certain information. The big question here is, does the government have to show that releasing this info would actually harm the businesses involved to keep it confidential, or is simply saying, hey, we promised we'd keep it quiet enough?
And the case itself is all about some pretty specific data. Store-level redemption data, which basically tracks how people are using government assistance programs like food stamps at different grocery stores. The Food Marketing Institute, or FMI, which represents the grocery industry, is fighting hard to keep this data under wraps. On the other side, you have Argus Leader Media, a news organization that's pushing for transparency, arguing the public has a right to know this stuff.
Exactly. Argus Leader Media says this data could shed light on how government money is being spent and how these assistance programs are actually working in communities. They're saying, hey, this is public money, and the public has a right to know how it's being used.
So let's dig into the arguments a bit. FMI is basically saying that the store-level data is confidential simply because it was given to the government with the understanding that it would be kept secret. They're pointing to like a 40-year history of the government promising confidentiality. They're saying the very definition of confidential is about whether the information is kept secret, not necessarily about whether releasing it would cause some specific harm.
Right. They're really focusing on the promise and the expectation of secrecy. Their argument hinges on the government's assurances.
Okay, makes sense. So what's the counter-argument?
Well, Argus Leader Media is hitting back pretty hard. They're saying, hold on. Just because the government promised to keep it secret doesn't automatically make it confidential under FOIA. They argue that for commercial information to be truly confidential under Exemption 4, the government has to show that releasing it would likely cause competitive harm to the businesses involved.
Competitive harm. So like if one grocery store could see how much their competitor was making from food stamp redemptions, it could give them an unfair advantage.
Precisely. They're saying the government needs to demonstrate that there would be some tangible negative impact on businesses if this data were out in the open. And they point to a long line of court decisions that support this likely competitive harm, standard decisions that go all the way back to a landmark case called National Parks.
Interesting. So we've got FMI emphasizing promises and secrecy, and Argus Leader Media pushing for proof of potential harm. And then, just to add another layer to all this, the government itself steps in as an amicus curiae, which basically means they're weighing in as friend of the court.
Yeah, the government filed a brief supporting FMI's position. They're saying, look, we think this data is confidential and we shouldn't be forced to release it. They're backing up this stance with two main arguments.
Let me guess. The promises they made and the nature of the data itself.
Spot on. First, they point to those long-standing assurances of confidentiality they gave to businesses over the years. They're saying it's a matter of trust and respecting those promises. And second, they argue that store-level data like this is inherently sensitive in this context, especially when it's so closely tied to government payments.
Okay, before we get too lost in the arguments over confidentiality, it's worth mentioning that there were some pretty intense procedural debates in this case, too. Like, the justices really grilled the lawyers about whether FMI even had the right to bring this appeal in the first place.
Yeah, that standing question was a big deal. You see, the government initially decided not to appeal a lower court ruling that went against them. But FMI wasn't ready to give up, so they stepped in and filed the appeal themselves.
Ah, so FMI had to become an official party to the case to have a chance to appeal the lower court's decision. They're basically saying, hey, this is our data and we have a right to fight for it.
Exactly. But Justice Sotomayor was really skeptical of this. She brought up a key point. If the government was really committed to keeping this data confidential, why didn't they just ask the district court to reconsider its ruling after a related law changed a change that dealt with a different FOIA exemption?
So she's suggesting that the government might be trying to get around their own decision not to appeal directly by letting FMI take the lead.
That's the implication, yeah. She even used the phrase piggybacking to describe it.
Makes you wonder what the government's true motives are here.
Right. And then Justice Breyer throws another wrench into the gears. He raises this whole question of mootness, basically, whether the outcome of this whole debate about Exemption 4 even matters.
How so?
Well, he pointed out that there's another law, completely separate from FOIA, that might already prohibit the disclosure of this data. It's called Section 2018C. So even if the court sides with FMI and says this data is confidential under Exemption 4, it might not change anything in the real world if this other law already prevents the government from releasing it.
It's like if the court ruled on whether you can use a coupon for a product that's already sold out, the coupon doesn't really matter at that point.
Exactly. But FMI's lawyer pushed back, saying the court specifically agreed to hear this case to clarify the meaning of Exemption 4, suggesting they intend to rule on it regardless of other potential legal obstacles.
Okay, so lots of procedural back and forth. Let's get back to the heart of the matter. This whole debate about what confidential really means in FOIA.
Right, so FMI's core argument is that confidential simply means the information is kept secret, period. The reason it's kept secret is irrelevant, they say. They argue that FOIA Exemption 4 isn't about harm or potential harm. It's just about whether the information was communicated and kept in confidence. They put a lot of weight on those government assurances of confidentiality.
I'm starting to see why this is a Supreme Court case. This is getting pretty nuanced.
Oh yeah, for sure. And it gets even trickier because FMI drew a comparison with legal situations where proving harm is essential. Like in tort law, those are cases about civil wrongs. They're basically saying, look, FOIA is different. It's not about who gets hurt. It's about protecting information that was shared in confidence.
Okay, to their point. So how did Argus Leader Media counter that?
They argued that the term confidential commercial information in FOIA shouldn't be viewed in a vacuum. They said it should be interpreted in light of how these concepts, trade secrets, confidential business information, have been understood in common law, which is the body of law built up over time through court decisions.
So they're bringing in this historical context to say that confidential has always involved some idea of harm resulting from disclosure.
Precisely. They're essentially saying this is how courts have always understood these terms, and Congress likely had that same understanding when they wrote FOIA.
Makes sense. Now, what about those government promises? Did the court just take those at face value?
Not exactly. The government was obviously leaning heavily on those promises, arguing that they created a clear expectation of confidentiality, and that's enough to justify withholding the data.
Yeah, we promised we wouldn't tell, so it's confidential kind of thing. But it sounds like Argus Leader Media wasn't buying it.
Right. They pushed back hard. They basically said, hold on, a government promise shouldn't automatically trump the whole purpose of FOIA, which is to make government information public.
Especially when we're talking about how taxpayer dollars are being used.
Exactly. And some of the justices seem to agree. Justice Ginsburg, for example, emphasized that FOIA is meant to make information public, even when the government might want to keep it secret.
So it's not just a simple matter of the government saying, pinky swear we won't tell.
Nope, not at all. Justice Kagan even grilled the government's lawyer about exactly what they were basing their confidentiality claim on. Was it the inherent nature of the data itself, or simply those promises?
You know, is there something about this store-level data that's so sensitive that it deserves protection? Or are they just relying on those promises?
Right. And the government's answer was interesting. They said that in this specific case, they were relying more on the promises. They acknowledged that the data is closely tied to government payments, but their main argument was built on those assurances.
Interesting. So lots of back and forth about promises, secrecy, and the nature of the data itself. But one of the most interesting parts of this case, I thought, was this whole debate over in the likely competitive harm standard.
Oh, yeah, that was a major point of contention. Argus Leader Media was adamant that this standard has to stay. They emphasized that it's been the established interpretation of Exemption 4 for 45 years, ever since that national parks case we talked about.
And they're basically saying Congress has had plenty of chances to change it, but they haven't, so that means they agree with it.
Right. They also argued that this standard is actually pretty workable. They pointed out that in this very case, the district court had already looked at the evidence and found the government's claims of potential harm to be pretty weak.
So even under this existing standard, it's possible that the data should be released.
Exactly. But FMI was fighting back hard, saying, look, forcing us to prove substantial competitive harm would make these legal battles way too complicated and expensive. They argue that the simple word confidential in FOIA doesn't require all that.
So they want a simpler test, one that doesn't involve all this economic analysis and expert testimony.
Right. Justice Breyer even jumped in, wondering if maybe some harm, even if it wasn't specifically competitive harm, should be part of the definition of confidential.
I can see his point. Like, maybe you don't have to prove it would hurt your business competitively, but maybe you have to show some kind of negative impact.
Right, that's an interesting middle ground. And then there's the whole issue of the 2016 amendments to FOIA, which now say you have to show foreseeable harm for all FOIA exemptions.
Ah, so does that mean this whole debate is moot now? Like, does it even matter what the court decides about the likely competitive harm standard?
Well, the amendments don't directly apply to this case because it was filed before 2016, but they do suggest that Congress now generally expects some consideration of harm when deciding what information to keep private. And that kind of undermines FMI's argument that harm should be completely irrelevant.
It definitely muddies the waters.
For sure. And then there was this whole other debate about the role of common law definitions in interpreting FOIA. Argus Leader Media argued that when Congress used those terms trade secrets, confidential commercial information, they were deliberately drawing on established legal concepts that usually include a component of harm.
So they're saying Congress didn't just pull these terms out of thin air, they meant something specific.
Exactly.
Yeah.
But FMI countered that by saying, well, confidential business information isn't actually a precisely defined legal term of art in common law.
So they're saying there's no clear, universally accepted legal meaning for those terms.
Right. And they kept circling back to their main point. Whether something is kept secret is a different question from why it's kept secret. And they believe harm is about the why, not the whether, at least when it comes to FOIA.
Okay, so we've got competing interpretations of the law, the role of common law, and this whole debate about harm versus secrecy. It's a lot to unpack.
Yeah, it's a real head scratcher. And then you throw in this principle of congressional ratification, which basically means that when Congress reenacts or amends a law that the courts have been interpreting in a certain way, it's like they're implicitly saying, yeah, we're okay with that interpretation.
So Congress is kind of putting their stamp of approval on how the courts have been applying the law.
Exactly. Argus Leader Media argued that this is exactly what happened with the likely competitive harm standard. Congress has had multiple opportunities to change it, but they haven't, so they must be okay with it.
That's a pretty strong argument.
It is, but FMI tried to distinguish this case from situations where common law is more directly relevant. They also kept hammering home their point that the word confidential itself doesn't inherently imply harm.
Okay, so after all that back and forth, where do you land on this? It's time for our 10th chair segment. Imagine you're the 10th justice on the Supreme Court. How would you rule on this case?
That's a tough one. You know, on the one hand, I really do think those government assurances of confidentiality carry a lot of weight. These businesses handed over their data with the expectation that it would be kept private, and breaking that trust could have some serious consequences.
Yeah, that seems like a slippery slope.
Right. But then again, FOIA is all about transparency and holding the government accountable. Creating exceptions to that principle should require more than just a promise. You know, the term confidential, especially within a law that's designed for disclosure, seems to imply that there needs to be a reason for keeping something secret, a reason that goes beyond just wanting to keep it quiet.
So maybe harm is part of that equation.
I think so. And looking at the history of FOIA and how courts have interpreted it, especially this long-standing likely competitive harm standard, it seems like Congress has, at least implicitly, accepted that harm is a relevant factor. The 2016 amendments requiring foreseeable harm kind of reinforces that idea, too.
So are you saying you'd side with Argus Leader Media and say the government has to prove likely competitive harm?
I'm not sure I'd go that far. I think strictly adhering to that standard in every case might be too rigid. But I do think there should be some kind of demonstrable harm requirement, maybe not specifically competitive harm, but some showing that releasing this information would genuinely hurt the businesses involved.
So you're talking about real, tangible harm, not just the businesses saying, well, we'd prefer to keep it secret.
Exactly.
Yeah.
I think that kind of middle ground respects both the government's role in assuring confidentiality and Congress's intent to protect legitimate business interests, while still upholding the core goals of FOIA.
It's definitely a balancing act. Well, there you have it. That's our deep dive into this fascinating and complex Supreme Court case. We've explored the arguments about what confidential really means in FOIA, the role of government promises, the debate about harm, and the importance of finding the right balance between transparency and protecting business secrets. It's a lot to consider.
It really is. This case raises some big questions about government transparency and the limits of FOIA. It'll be interesting to see how the Supreme Court ultimately rules and what impact that has on future cases.
Absolutely. And as always, we encourage you to keep exploring these issues. Think about the weight of government assurances, the role of harm in defining confidential, and the constant tension between the public's right to know and the need to protect certain types of information. It's a debate that's likely to continue for a long time.
And that's what we're here for, to break it all down for you.
Exactly. So until next time, keep those legal minds churning.
See you there.